This is the Making the Tough Call podcast. I'm Katherine Crace, a social worker, lawyer, and longtime trainer in professional ethics. Please note that while I am an attorney licensed to practice law in New York State for over 20 years, I'm not your attorney. Nothing I say in my recordings should be considered legal advice. Today we're going to talk about when a therapist might have a duty to warn or protect someone from harm. Mental health professionals learn early in their education and training about their ethical and legal obligation to keep client information private. This is referred to as client confidentiality. Confidentiality relates to the responsibility of certain professionals, like therapists, to keep client information private. The preservation of client confidentiality is considered necessary in order to encourage clients to tell their mental health professionals information that they don't want others to know about. Only with this information can mental health professionals be most helpful to their clients. If a client is afraid that their therapist will tell others what they say, they won't tell their therapist their private thoughts or experiences. And these thoughts and experiences are vital to the therapist's understanding of the client's condition and circumstances. Without this information, the therapist will be limited in how they can help and support their client. While the obligation to preserve confidentiality is generally vast and supported by law and ethical codes, there are limits. The therapist's obligation to protect client confidentiality is challenged when the client tells the therapist something that makes the therapist concerned that the client is in danger or someone else is in danger. In these situations, the client, with their otherwise confidential communication, might trigger the therapist's legal or ethical duty to warn or duty to protect. The obligation of mental health professionals as mandated reporters of suspected child maltreatment is one related area. You can find out more about how to talk to your clients about your role as mandated reporter at our website. Let's talk about the Tarasoff case. Many mental health professionals learn about the duty to warn or the duty to protect through an examination of the Tarasoff versus Regents of California case. In 1969, a graduate student told his campus-based therapist that he planned to kill a female student who he was obsessed with and stalking. Her name was Tatiana Tarasoff. The therapist informed the campus police of their concerns. The campus police briefly detained and released the graduate student after assessing him as rational and having him promise to leave Tatiana alone. No one ever contacted Tatiana, and she was killed by that graduate student. Her family sued the school and the therapist, claiming that they had a duty to protect or warn her. The court in California back in 1969 agreed and declared that the therapist, quote, pursuant to the standards of their profession, should have so determined, but nevertheless failed, to exercise reasonable care to protect her from that danger. In other words, the therapist should have attempted to warn Tatiana directly. The Tarasoff duty is largely seen as the duty to protect or the duty to warn people whom the therapist reasonably believes are in danger. The law and professional codes of ethics do not require the therapist to stop the harm from occurring, but to take what we call reasonable care to prevent that harm. Not every state has the same law as it relates to the duty to protect and/or warn. There is a website you can find linked on my website that shows clarity on state differences. The differences by state are in statutory and case law variations across jurisdictions. Some states require the therapist to warn the intended victim directly, like in California. Some states require the therapist to inform a government agency like the police. That's the case in New York. Some states require both actions, and some states require nothing. California has some of the most expansive expectations, whereas there are still some states who have absolutely no legal expectation that a therapist will warn or protect anyone. In order to determine if you, as a therapist, have the duty to warn or protect, courts and legislatures have generally considered the following conditions. Do you have a special relationship which results in you having some level of duty to another person? In Tarasoff, the therapist was seen as having a special relationship with the graduate student that gave the therapist a level of control over his actions. The next thing to consider is, do you have a reasonable prediction of harmful conduct of a serious nature? In Tarasoff, the therapist seemed to have a pretty reasonable prediction that the graduate student would act on their plan, and that's why they contacted the campus police. The third question to ask yourself is, do you know of a foreseeable victim? In Tarasoff, the court ruled that since the therapist knew the identity of the intended victim, their obligation did not end when they informed the campus police. They should have attempted to contact Tarasoff directly to warn her. It can be helpful when considering the duty to warn or protect, to consider the context of the 4 basic ethical principles, beneficence, non-maleficence, autonomy, and justice, that I've discussed in other blogs and podcasts. You can find them linked on my website. When a therapist considers breaching client confidentiality out of a duty to warn or protect, they should consider whose beneficence they are intending to preserve. In this case, they are specifically prioritizing the well-being of the identifiable victim. The therapist should also consider their obligation to minimize harm under the ethical principle of non-maleficence that might come from the breach of client confidentiality, namely the loss of trust of the treating professional. If the therapist breaches confidentiality in order to inform law enforcement or warn the intended victim, the client might feel aggrieved or harmed, even if that harm was necessary to protect the intended victim. That client might never trust another mental health professional and never tell them in the future if they intend harm on another. The duty to protect or warn also implicates the therapist's professional autonomy or choice. The therapist might report to law enforcement out of fear that if they don't, they will get in trouble, but simultaneously recognizing that this breach will damage their professional relationship with the client, making it more difficult to engage with and help that client. So the therapist should also consider justice. Therapists should make efforts to ensure the application of their duty to warn or protect is applied without impact of race, gender identity, age, or other protected class. A breach of client confidentiality has considerable consequences that should not be unfairly experienced by some groups more than others. The clinician should also make sure that the client continues access to assessment and clinical intervention to address the underlying concerns that led to the duty to protect. Without those efforts, the client is likely not to be helped by a report, and the risk to others and themselves remains. Many therapists also wonder what they're supposed to do when they have concerns the client might harm themselves. If a therapist has concern that their client is at risk of causing self-harm, they might also have a duty to protect or warn. The therapist should consider the first same 2 factors as in duty to warn or protect others. Do they have a special relationship? If the concern comes from your professional relationship with the client, you have a special relationship. Do you have a reasonable prediction of harmful conduct? Not all ideations of self-harm should lead a therapist to have a reasonable prediction of harmful conduct. Therapists should be aware of up-to-date assessment methods to help inform their evaluation of the likelihood of self-harm. The American Psychological Association has a great blog on the topic of assessment and intervention with patients at risk of suicide. You can find the link at my website. If a therapist has a reasonable prediction that their client is going to seriously harm themselves, they are likely required by the law in their state to make an effort to inform someone or some entity of their concern. When the client is an adult, they will likely need to discharge their duty by informing the police or the health department. If the client is a minor under the age of 18, they will likely need to discharge their duty by informing the minor's parents or caretakers. If the minor's parents do not seem to adequately respond to the therapist's concerns, a report to Child Protective Services or law enforcement or the health department might be required by state law, but a report to a government agency when a minor is at risk of self-harm is not required if the parent is taking appropriate steps to mitigate risk to the child. Most importantly, the clinician should also make sure the client continues access to assessment and clinical intervention to address the underlying concerns that led to the duty to protect. Without those efforts, the client is likely to not be helped by the report, and the risk to self remains. The duty to warn has been expanded beyond Tarasoff expectations. In 2004, another case in California, Ewing versus Goldstein, brought a particular set of circumstances that complicated the Tarasoff evaluation. In the Ewing case, a California therapist had concerns about their adult client's worsening depression after the client's former partner started a new relationship with another person, Ewing. The therapist sought and received client permission to talk to their parent. The parent relayed to the therapist concern that the adult client was going to harm the new partner. The therapist instructed the parent to have the adult child committed to inpatient psychiatric care. After a brief stint in inpatient care, the adult client was released against the objections of the therapist and subsequently killed Ewing as well as themselves. Ewing's family sued the therapist, asserting that the therapist should have made an attempt to warn Ewing directly. The California court agreed with the Ewing family, thus expanding the definition of special relationship and finding that it's the therapist's duty to warn can be implicated by communications other than those from the client directly. The Ewing decision is a California state and is not considered binding in all states. However, therapists should be aware of the case and the potential applicability to their own practice. There was substantial pushback from therapeutic professional groups after the case in Ewing. Groups like the APA and others have serious concerns that the Ewing decision will open up therapists to wider liability and discourage clients from sharing vital information with their therapists under the expectations of confidentiality. Clients are best protected when their therapist makes decisions balanced by the considerations of the 4 ethical principles of beneficence, non-maleficence, autonomy, and justice. When therapists are more concerned about their own potential legal liability than their ethical obligations to their clients, they are constrained and further clients can suffer. If you'd like more information and resources, as well as other training opportunities, check out our websites. Thank you.